Guys, everyone sit down.
People get their food.
No, I just want to make sure my bag wasn't protruding out.
I'll hand it over to you. Hi, everybody. Whoa, welcome. I'm Fernando LaGuardia. I'm the director of the Program on Law and Government, and we are sponsors of today's event. Delighted to see you all here. Before we get started, and Professor Wermiel is going to introduce our panel, I just want to say a few words. You may not know this, but this year marks the 20th anniversary of Professor Steve Wermiel's tenure on the faculty at WCL. During that time, and I told him I was going to embarrass him, so he knows something's going on. During that time, he's taught constitutional law, First Amendment, a seminar in the Supreme Court to thousands of students, hosted hundreds of forums and events, and had a unique role as co-founder and first associate director of the Marshall Brennan Constitutional Literacy Project, which is also celebrating its 20th birthday in April. Founder of the Jurist in Residence program, which celebrated its 10th birthday last year, and the Law and Government Summer Institute, convener of wildly popular events about the Supreme Court, such as this one. It's great to see you all here. And he's even served as acting director of the Program on Law and Government itself. He's chaired the Public Interest Public Service Scholarship Committee, coached WCL's wildly successful moot court teams, served as faculty sponsor to a wide range of student organizations. In fact, pretty much any student organization who asks, Professor Wermiel will help. Put in thousands of miles with WCL abroad, worked tirelessly to help students find jobs and internships, and is routinely, and this is the thing I think faculty members admire him most for, the top-selling faculty donor at the annual EJF charity auction each spring. His Facebook page is legendary in a good way, and his office is filled every day with students seeking his advice and counsel. His generosity of spirit is no surprise, as he is, after all, a proud WCL alum who has been giving back to the school ever since he graduated. Having said that, I also want to add on a personal note that my own transition to WCL was made even warmer and easier with Steve's help. But I think I can say no one cares more about WCL and our students. No one advocates more strongly for them. No one stands up on their behalf more regularly. So thank you, Steve, for being a model colleague, teacher, mentor, and friend. This is just the start at our small effort to let you know that all of us appreciate everything you do and have done to make WCL a better place. Please join me in a round of applause for Professor Wermiel.
Thank you, Fernando. When my Supreme Court nomination comes through, I'll ask you to introduce me. Thank you very much, Fernando. Fernando is the director of the Program on Law and Government, which is the co-sponsor of this event today, along with the American Bar Association Division for Public Education. We're very happy to have Kathy Hawk here from Chicago with the ABA, who helped organize the event and who's helping to sponsor it today. And thank you all for being here. Thank the panelists for being here. So we're going to do a few things. We're going to talk about some cases the Supreme Court has already agreed to hear and has on its docket. Then we're going to talk a little bit about some cases that may be coming along that the court hasn't yet agreed to hear. And then there might be this other aspect of the Supreme Court going on that you might have a passing interest in called the nomination process, and we might try to say a few words about that as well. So just by way of quick introduction, you all have bios of the speakers in the programs that are on your table, so I'm not going to spend time introducing them except very briefly as I recognize each of them to talk about cases. By way of quick background, the Supreme Court has room in this current term on its docket for about 80 oral arguments. In recent practice, they have only used up about 60 of those 80 slots and have been stretching to fill those 60. They have already filled about 37 slots for oral argument this term. So we presume they will be adding something like 20 to 25 more cases to the docket later this week and in the days ahead. What we're going to start with is talking about roughly about 8 of the 37 cases that the court has already agreed to hear in the term that starts next Monday. Next Monday is the first Monday in October, which by statute is when the court term begins. There are some variables that we hadn't planned on when we organized this program. Like we thought there'd be 9 justices sitting on the court, and that would affect how we viewed the cases that we're talking about. Whether we think it makes a difference that some of these cases may be heard with only 8 instead of 9 is something we can factor into the discussion. So each of my panelists is going to do one case, and then we'll go through a second time with a second round of cases, and then turn to cases coming up and the nomination process, and then try to leave time for questions from you before we run out of time. With that start, I'm going to turn first to Adam Liptak, who's the New York Times Supreme Court correspondent. He's been covering the court for a decade and actually has had 2 hats at the New York Times, well, 3, but 2 that I'm going to mention. One is the Supreme Court correspondent, and he also, interestingly, was in-house counsel on First Amendment issues for the New York Times for 10 years before he moved to the news side and then became Supreme Court reporter. So he's seen some of the things we're talking about from 2 different sides. And Adam is going to talk first about a case involving the excessive fines clause.
So I'll let you guys draw your own conclusions, but you might think by the end of our discussion that there have been Supreme Court terms with more blockbusters than this one. We're going to talk about some cases that are reasonably interesting, but may not make the front page of the newspaper when decided. That said, the one I'm going to talk about has 2 nice features. It's easily accessible, the facts are understandable, and it presents a substantial constitutional question. So a reporter shouldn't ask for much more than that. This is the story of Tyson Timms and his Land Rover. Tyson Timms inherited about $73,000 when his father died, and he did one reasonably smart thing and a bunch of stupid things. The reasonably smart thing is he always wanted to buy a Land Rover, so he bought himself a Land Rover. And then because he was an opioid and then heroin addict, he spent the rest of it on drugs. That wasn't particularly wise. I interviewed him, and he told me, unfortunately, I had a whole bunch of money, which isn't a good idea for a drug addict to have. I used a lot, and eventually the money ran out. It was an addict's life. In the process, he sold some heroin, $225 of heroin. He made the unwise move of selling them to undercover police officers. And he was caught and charged and sentenced to a year of probation and fined $1,200. And that may strike you as, roughly fair. But the state of Indiana did something else. It also seized his Land Rover under a civil forfeiture law. And those laws are quite controversial, and not only among liberals. Justice Clarence Thomas, in an opinion, said that civil forfeiture has in recent decades become widespread and highly profitable, and because the law enforcement entity responsible for seizing the property often gets to keep it, those entities have strong incentives to pursue forfeiture. So for a $225 crime, the state of Indiana seizes a $43,000 Land Rover, and Tyson Tim goes to court and says that's not fair. And he wins in the lower courts. They say that seizing the Land Rover in these circumstances violates the federal Constitution's excessive fines clause in the Eighth Amendment. And it goes to the Indiana Supreme Court, and the Indiana Supreme Court says, you know what, we're not sure that Eighth Amendment provision applies to us. The U.S. Supreme Court has never squarely said that that provision applies in state proceedings, that it's been incorporated against the states. Most provisions of the Bill of Rights, piecemeal, have been incorporated by the Supreme Court through the 14th Amendment to say just as they initially applied to the federal government, they also applied to the state government. And the court has said some loose things indicating that the excessive fines clause may also be incorporated, but it said so in what lawyers call dicta, in an aside, not crucial to the holding of the case. So here we have an authentic constitutional claim. Does the excessive fines clause apply to the states? We have a sympathetic plaintiff, and Tyson Timbs has gotten lots of support from across the ideological spectrum, including, say, the Chamber of Commerce, which you wouldn't think would be particularly interested in helping out heroin dealers. But the Chamber of Commerce cares about the excessive fines clause because it also figures in punitive damages analyses. So here's a case which won't be hard to write about, which has a good constitutional question in it, and that is a blessing for a Supreme Court reporter.
Thank you. Nice and succinct. Next, we're going to turn to Sarah Harrington, who is a lawyer at the firm of Goldstein and Russell. She was an assistant to the Solicitor General of the United States for 8 years and argued 20 cases in the U.S. Supreme Court before moving to the Goldstein and Russell firm, the firm that was founded by our alum, Tom Goldstein. And Sarah has the unusual task of talking about a case that combines sex crimes, separation of powers, and administrative law all into one shot.
Yeah, so this is a case about Mr. Gundy. Mr. Gundy was someone who was convicted of a cocaine offense, a federal offense, served his time in prison, but then while he was on supervised release, he gave cocaine to an 11-year-old and then raped her. He was prosecuted by the state and served time, but then also had to serve time, more federal time, for violating his terms of supervised release. In the course of his federal custody, he was moved from one state to another state when he moved into a halfway house and then when he was released. When he made those moves, he did not register as a sex offender. So then he was later prosecuted again for failing to register. So this case involves a statute called SORNA, or referred to as SORNA. It's the Sex Offender, I think, Registration and Notification Act. And it has spawned a lot of cases that go to the Supreme Court. It's a federal law that does a few things. It gives incentives to states to create sex offender registries, but it also attaches criminal penalties to the failure of people who've been convicted of qualifying sex crimes when they travel interstate or internationally. If they don't register, there are criminal penalties. This case also involves a constitutional doctrine called the non-delegation doctrine, which is a separation of powers principle that says basically, as a general rule, Congress does not have the ability to delegate its legislative authority to another branch of the government, to the executive branch. The Constitution gives Congress in Article I the authority to legislate. It doesn't give that to the executive branch. Now, of course, As a practical matter, Congress does rely on the executive branch to implement the laws that it enforces and gives the executive branch agencies some authority to sort of fill in the details through regulations and otherwise of laws that Congress passes. But so there's sort of an exception to the non-delegation doctrine that allows that kind of cooperation from the executive branch, but there needs to be what the court has called an intelligible principle in the delegation. So Congress has to identify the policy that the executive branch agency is supposed to implement, has to identify the agency, and has to sort of give some bounds to the discretion of the executive branch. In SORNA, Congress was trying to figure out whether it should apply the registration requirements in SORNA to pre-act offenders, so people who had been convicted of a qualifying sex crime before SORNA was enacted. And it was hard to figure out because there are a lot of practical problems because most of these crimes are state crimes and many of these people are out of the system. And so there were practical problems about how it's going to work, how much of a burden is going to be on states. And so Congress basically kicked that decision to the Attorney General. So there's a provision in SORNA that says the Attorney General shall have the authority to specify the applicability of the registration requirements of SORNA to pre-act offenders. And after some initial inaction and then an interim rule that was challenged, the Attorney General went through some rulemaking and decided basically to apply SORNA to all pre-act offenders. There have been some fluctuations in exactly whether everyone's covered, but that's sort of the basic rule now, everyone's covered. And so Mr. Gundy was convicted in his latest conviction on that basis. He was a pre-act offender, didn't register. And so he challenged that provision of SORNA as a violation of the non-delegation clause. So he says basically this delegation is totally unguided. It just says the Attorney General shall have the authority to specify the applicability to pre-act offenders. There's no like, what should you consider? You know, do we want you to do it? Do we not want you to do it? It's just like, it's up to you, Attorney General. The government in response says, no, it's not. There is an articulated policy in the statute as a whole. Congress wanted sort of the maximum coverage to the extent practicable is what they say. They wanted to cover everybody we could practically cover. And this sort of guidelines of the exercise of discretion is the practicable part, that the Attorney General is in a better position to figure out, like, is it practicable? Can we cover everybody? Should we not cover some people? And that sort of guides the discretion that has been given to the Attorney General. So there's two sort of related doctrinal questions in the case. One is sort of the SORNA-specific question. Does this delegation exceed the boundaries set forth in the non-delegation doctrine? And the second is sort of what should the restrictions be in this kind of a context? Should there be sort of a higher bar for Congress to delegate in a criminal context where basically you're saying to the top prosecutor, hey, this is what the defendant says, hey, you get to decide what's a crime, and then you get to prosecute it. That doesn't feel like the way our system works. It doesn't feel like the right kind of checks and balances. So maybe it should be a higher bar in a criminal context. Maybe it should be harder when you have sort of questions of retroactivity in play, as you sort of do in this context, when you're talking about the federal government kind of stepping on an area that's traditionally a state area, or when you're imposing a burden on states as sort of happens here. So just thinking about trying to read the tea leaves about what might happen in this case. So on the side of the government, the court has rejected almost every non-delegation challenge in history. So the U.S. has momentum, doctrinal momentum on its side. The defendant has the grant of cert on his side in the face of no circuit split. So every court of appeals that had stared down a non-delegation challenge to SORNA had said there's no problem here, and yet the court granted cert. So that's a pretty good indication that the defendant has some reason to feel confident. Also, in a case several years ago, a different SORNA case called Reynolds, Justice Scalia wrote a dissent that was joined by Justice Ginsburg, where they expressed some skepticism about SORNA's delegation and said they wanted to interpret the language of that provision differently because they thought it hewed, I can't remember the exact phrase Justice Scalia used, but basically it was really close to the line and possibly crossing the line on the non-delegation. So I think that puts a little bit of wind in the sails of the defendant, and also Justice Gorsuch, when he was a judge in the 10th Circuit, filed a dissenting opinion dissenting from the denial of rehearing en banc, similarly expressing a view that this feels like a problem. So I think Certainly, if we had a 9-member court, I think you, and maybe we will by the time the case gets decided, there would be some reason for the defendant to feel some confidence at least. There's also a couple other things kind of working in the background that are to the benefit of the defendant. The first is there's been this sort of growing sense among at least some of the justices on the court, some of the more conservative justices, that the federal government in its exercise of its criminal authority is going too far, that they're just not making the right kind of judgments about what to prosecute, what kind of sentences to ask for. There's sort of been, especially this has been particularly come out from the Chief Justice, but also some of the other justices. There's just a view that like it's just that DOJ is just doing too much, that they're not exercising enough common sense and showing enough restraint. And so I think that could color how some people view this particular delegation, and there are ways to rule against the government and to say, well, this is just a criminal, this is a special rule for criminal cases and there's retroactivity and stuff. There's also sort of a growing hostility among the conservative justices to agency action and to just, sort of deferring to agencies' judgments. There's certainly Justice Gorsuch and Justice Thomas have expressed that view. Judge Kavanaugh has expressed that view. So if he ends up joining the court, I think that could be a boon for the defendant. In terms of sort of the implications, so you could have sort of these broader implications for agency law generally if the court takes this opportunity to kind of cut back on, or to say bad things about deferring to agencies. This isn't a Chevron case, but they could sort of say things about the proper role of an agency in sort of doing what it would view as lawmaking or legislating. In a narrower sense, I think whatever happens in this case, Congress can just fix it if it sees it as a problem. So if the court says that this is too much, there's no guidance, Congress can either make the judgment itself about retroactive application, or it can just pass a new statute with a little more guidance, and we would end up right where we started.
I put you on the spot and said, guess whether it'll be broader or narrower?
I'm going to go with narrow, yeah.
Okay. All right. So my colleague Angela Davis, who's a professor here at the Washington College of Law, teaching criminal law, criminal procedure, defense strategies, practice clinic, and accomplished author of a couple of books about the misdeeds of prosecutors, and a former head of the Public Defender Service, has 2 death penalty cases she's going to talk about. We'll do one first and then finish some other cases and then come back to the second one.
Thanks, Steve. So the first death penalty case I'm going to talk about is Madison versus Alabama. And this is a case in which Mr. Madison is basically saying that he is incompetent to be executed. So that's the issue that the court is facing. Mr. Madison was found guilty of killing a police officer and sentenced to death 3 times. He had 3 trials. The first time was in 1985. He was convicted, but his conviction was reversed by the Alabama Court of Criminal Appeals based on a Batson violation. Some of you may know the case Batson versus Kentucky, in which the United States Supreme Court held that an individual may not be struck from a jury based on his or her race. And in this instance, all 7 African-American members of the jury pool were struck by the prosecutor. And even the Alabama Court of Criminal Appeals found that that was reversible. So then he had his second trial, and in his second trial, his defense was that he was not guilty by reason of a mental disease or defect. He was convicted again, sentenced to death again. The Alabama Court of Criminal Appeals again reversed his conviction, this time based on prosecutorial misconduct, which must have been pretty bad because it's really difficult to get a reversal based on prosecutorial misconduct. So then he had his third trial in 1994, and at the third trial, his defense was that he acted in self-defense. Remember, he killed a police officer, which is, of course, one of the crimes for which prosecutors frequently seek the death penalty. He was found guilty a third time, this time during the penalty phase, and everybody knows how death penalty cases work. It's a bifurcated trial. There's what's called the guilt phase, which is just a regular trial where the jury decides whether the person's guilty, whether the government's proven that person's guilt beyond a reasonable doubt. And then the second phase, if the person's found guilty, the second phase is what's called the penalty phase, or the death phase, as some people call it, where the jury decides whether the person gets the death penalty or life without parole. So in this third trial, during the penalty phase, which is when the government tries to prove a number of aggravating factors and the defense then presents what they consider to be mitigating factors, and then the jury weighs them in deciding whether the person's going to get the death penalty. So during the penalty phase this time, Mr. Madison put on a great deal of evidence about his mental illness. He had mental illnesses for a good part of his life. He'd been on a lot of numerous medications, and based on that evidence, the jury decided that he should get life without parole instead of the death penalty. However, in Alabama, they had a practice called judicial override, and in which the judge could actually override the decision of the jury in death penalty cases. And Alabama is the state that was most notorious for using that. I think Florida had that provision, as did Delaware. No states have it now. In fact, even Alabama abolished it last year, but they did have it at the time of this trial, and the judge overrode the decision of the jury to sentence him to life without parole and sentence him to death a third time. So then in 2016, Alabama moved to set an execution date, but during that time, at the same time, that year, Mr. Madison's lawyer filed a petition to stay his execution based on his severe physical and cognitive decline. He'd had numerous strokes while he was incarcerated. And one of them was something called a thalamic stroke, which really destroys the brain tissue and causes you to lose your memory. And he had absolutely no memory of committing the offense. And so a Mobile County judge decided to allow a competency hearing to decide whether he was competent, and appointed an expert, a doctor, Dr. Carl Kirkland, to represent the state and to evaluate him, Mr. Madison, and give testimony about whether he was competent to be executed. And then the defense hired an expert, Dr. Goff, and they both testified, Dr. Goff saying that he wasn't competent, Dr. Kirkland saying that he was. It was undisputed at that time that he'd had numerous severe strokes that had left him legally blind, with significant memory loss, significant cognitive decline. He had what's called vascular dementia. He was unable to walk on his own. His speech was severely slurred. You couldn't even understand him, and he was incontinent. Nonetheless, the court accepted the finding of the state's expert, Dr. Kirkland, and found that he was competent. Now, it was later discovered that just 4 days after this hearing, Dr. Kirkland, who at the time, well, let me just back up. It was later discovered that Dr. Kirkland was a drug addict. And then that just 4 days after this competency hearing, in which he testified that Mr. Madison was competent, he forged some prescriptions to get drugs and was ultimately charged with 4 felonies and was suspended from the practice of psychology. So that's the doctor on whose expert testimony the judge relied in deciding that Mr. Madison was competent. So these are the issues that will be decided by the Supreme Court: whether the state may execute a prisoner whose mental disability prevents him from even remembering the offense for which he was convicted, and whether the Eighth Amendment's prohibition of cruel and unusual punishment bars the execution of a prisoner whose mental condition prevents him from remembering the crime and even from understanding the circumstances of his execution. And this is not the first time the court has ruled on the issue of competency to be executed. In Ford versus Wainwright and Panetti versus Quarterman, the court addressed that issue and held that a person who is mentally incompetent cannot be executed, but the court was not clear about exactly what mental defects make a person incompetent. And so Mr. Madison is very ably represented by the great Brian Stevenson, who some of you may know from the Equal Justice Institute, who's Equal Justice Initiative, I think, not Institute, Initiative, EJI, who has a great record of winning cases in the United States Supreme Court, death penalty cases. And he's arguing that there's no deterrent value, no retributive value to executing someone who's in Mr. Madison's condition. The state, on the other hand, is arguing that Mr. Madison is competent, and the fact that he can't remember the crime does not make him incompetent. And they're also arguing that retribution has a value, and they're also arguing that there is a general deterrent value, that others will be deterred from committing this crime by his execution. So we shall see. It will be argued next week, October 2nd. So those of you who can get into the Supreme Court to see Brian Stevenson argue should go. Be quite a treat. Oh, I should also add.
Get in line
You may
now.
have to get in line now. I should also add that the American Psychological Association and the American Psychiatric Association have filed amicus briefs on behalf of Mr. Madison.
Thank you, Angela. Beth Brinkmann is a lawyer at Covington and Burling. She was the chief appellate lawyer in the Justice Department Civil Division for a number of years. She has a long-standing Supreme Court practice and has argued 24 cases in the Supreme Court. And she's going to tell us about an antitrust case that might actually be the one that has the most direct application to everyone in the room.
That's right. Well, thank you so much for having me here. I'm happy to be back. And I just have to mention when Steve was talking about the wonderful history of this law school and Steve being alum, I appreciate the fact that he mentioned Tom Goldstein, Sarah Harrington's partner, because when Tom Goldstein was a law student here, I had the privilege of being on the moot court panel that awarded him, without any question, first place in his moot court. So, we saw it early on where Tom was going. I like to claim that whenever I can, usually if Tom's, here. But anyway, so I'm very happy to be here. Thanks so much. And with these great colleagues up here learning all about the terms so we can be set to watch the press and the coverage on it. As Steve mentioned, I'm going to talk about an antitrust case. And for those of you who may not have taken antitrust law yet, it's a federal statutory scheme that is aimed at preventing monopolization and restraint of trade in order to protect competition. And the theory is protecting competition protects consumers. But like all areas of law, it's very complicated. It relies a lot on economic theory. Even the question of what a market is, takes significant debate. And in fact, last term, the Supreme Court had one case about what a market was, and they split 5-4. This case involves e-commerce and a digital platform. And so getting to the punchline here early, the name of the case is Apple v. Pepper. It's about iPhones and the iPhone App Store. The claim is by a class that could include, I'd say, the vast majority of individuals in this room who purchase apps from the App Store, that Apple has monopolized that market because Apple allows app developers to sell to users of iPhones only if they go through the App Store, and Apple charges the app developer 30% additional commission that goes to Apple. Very interesting question. But that is not the question the Supreme Court is going to decide because of like all things good in law, they're procedural and antecedent questions that arose. And that is a question of standing and whether or not the iPhone users who buy iPhone apps have standing to sue Apple under the antitrust laws, because in order to do so, they have to be direct purchasers. That theory goes as follows. The increase in price that would come about through monopolization and unlawful antitrust activity by the wrongdoer then can be sued by a direct purchaser, and that direct purchaser can recover treble damages under the antitrust laws. But if the entire chain down to the consumer could also sue the various, sub-distributors and all, there would be duplicative recovery, more than duplicative recovery, because everybody would be able to get treble damages against the alleged antitrust violator to begin with. So in 1977, the Supreme Court decided a case called Illinois Brick and said only direct purchasers can sue because the direct purchaser is the one that makes the decision and is injured by such a violation, and then they can pass on that injury perhaps to others, but the others would have to, go against the person who's passing on the increase in price, cannot have a duplicative cause of action to get the same damages against the original alleged wrongdoer. So you have to be a direct purchaser, and the injury you're claiming can't be because the increase in price was passed on to you. You have to be at that first line. You can see here there are going to be a lot of analogies and labels. So is Apple like a shopping mall where they're just, setting up this platform for sellers and buyers to come in, and they're not selling directly to the iPhone owner? Or is the iPhone owner actually paying that 30% commission directly to Apple? Here, the iPhone app developers have an interesting role to play because they would be the ones that could sue Apple if they believe there's monopolization. And when you look at how you would play out what the damages would be for the iPhone users, the developers have a key role because they set the price for the apps. And you could see that some developers might feel that they should absorb part of that 30% commission, not pass it all on, because they have a price point at which they need to, have their market buyers. So it's going to be a very interesting case that talks about these theories of Illinois brick. There was kind of a foreshadowing, I do think, in the cert grant in this case, because there was a disagreement in the courts of appeals, but a very old one. The case that the Ninth Circuit in this case disagreed with was a very old case in the Eighth Circuit involving Ticketmaster when it was first new, and that had gone in favor of Ticketmaster, which would be Apple's side here. Another interesting fact to always look at to see what side the government's on, and the Solicitor General's office here that represents the interests of the United States, which includes the Antitrust Division, supports Apple. This will be a real impact, perhaps, on a lot of different e-commerce. You can imagine there are these platforms that are multi-sided, how you order meals or find your vacation home. All of these are this kind of new area where they're bringing together different sides, sometimes more than two sides. You have the delivery guy in addition to the seller of the meal and the person buying it. There are also a lot of efficiencies that that come out of this because consumers today have a better ability to compare actually products, to get reviews, and to really have a more informed, efficient marketplace. On the other hand, this idea of this 30% commission, I think, will be described as a payment directly to Apple, that it's not really this kind of pass-through theory. Keep your eyes open. It'll be a very interesting case. I should say the Supreme Court doesn't take that many antitrust cases. They have this one. They had a significant one with American Express last year. And it really is, that also, as I said, involved a credit card and some of this multi-sided platform. It's bringing antitrust law into, the modern economy. So keep an eye on it.
Thank you, Beth. So we're going to go around one more time with another set of cases. I'm going to turn to Adam for a First Amendment / criminal procedure case. I'll invite the panelists as we go through this round. If you want to add anything to what we've already discussed, please feel free.
Okay. So this next case is called Neves v. Bartlett. And it's an instance of something I've come to see, having covered the Supreme Court now, I'm on my 11th term, is that they keep deciding the same cases over and over again. Or they keep trying to decide the same issues over and over again and not quite being able to do it, but maybe this time they will decide the following issue. So let's assume that you are mouthing off to a cop, and the cop arrests you purely because he or she doesn't like what you're saying. You then have a claim for retaliatory arrest because you have a constitutional right to say things, and if you're arrested solely for that reason, your First Amendment rights have been violated, and good for you. You should win that lawsuit. But what if the cop also had, independently, some other ground on which to arrest you? What happens then? What happens if it's undisputed that there's probable cause to arrest you for, loitering or jaywalking, but also part of the cop's calculus, or maybe all of the cop's calculus, was to retaliate against you for your First Amendment rights? What happens then? That's an open question in the law. We know that retaliatory prosecution is always, a claim for retaliatory prosecution is always defeated if there's probable cause. But is there a blanket categorical rule that probable cause defeats every single First Amendment retaliation claim? So the court has now 3 times tried to decide this question. And another thing that this discussion illustrates is that the facts really matter. In some factual settings, the court is likely to lean one way, and in others the other way. And I guess I'd say this latest case, probably not the best set of facts for the party claiming retaliatory arrest. So the first time this case comes up was when some protesters protesting against then Vice President Dick Cheney were arrested by the Secret Service, and the argument was that they'd been arrested for their protesting, not for other conduct. And at the oral argument of the case, the dynamics on the both sides were illustrated by the questioning, and it really kind of focused how hard this question is in a sense. So Justice Sonia Sotomayor says, well, there's got to be a claim here because in the modern world, everyone is constantly committing a crime. If the cop wants to come up with some make-weight probable cause, they can arrest you, she said, for jaywalking. Okay, that's one argument. Chief Justice Roberts says, well, wait a second. All I have to do is put an I hate the police bumper sticker on my car, and if I'm pulled over for speeding, I can sue because I can say, listen, in my view, I was arrested not for speeding, but because the cop didn't like the bumper sticker on my car. And so that sort of gives you the two schools of thought. The court manages not to decide the Secret Service case, goes off on other grounds, although there is a sense, even from the left side of the court, that the Secret Service might be special. The Secret Service really has high obligations to defend high public officials, and maybe that's not where we want to be deciding this case. The next day's case that comes up, much more sympathetic to the retaliatory arrest claim. It's brought by the great Fane Lozman, who is a Florida gadfly who's twice gotten to the court, twice won at the court. The first case, you should look it up, Chief Justice Roberts said it was his favorite case of that term, involved whether his houseboat was a floating home or not for takings purposes, not today's subject. He comes back to the court on the following claim, that he shows up at a public meeting, starts criticizing local officials, and is promptly arrested. And it turns out that there was something like an official policy to let's harass Fane Lozman in Riviera Beach, Florida. And the court doesn't decide the larger question. It just says, okay, if there's an official policy saying let's harass Fane Lozman gets to sue. That's like a ticket for one ride only kind of Supreme Court decision. And the larger issue is not decided. Now we have the third case. The third case arises out of an event I'd never heard of, perhaps you have. This is the characterization from the brief of the police officer involved. In the remote Hoodoo Mountains of interior Alaska, thousands of winter sports enthusiasts gather each spring for Arctic Man. I guess it's like Burning Man, but cold. A multi-day booze and fossil fuel festival bookended by the world's craziest ski race. Well, a lot of Alaskans go to this thing. It's lightly policed, and one, Russell Bartlett, has an interaction with a police officer. It's caught on videotape, but nonetheless, it's a little hard to know what's going on there exactly. Bartlett alleges that he was arrested because of the things he said and didn't say. The police officer said he committed assault, disorderly conduct, harassment, and resisting arrest. Those charges were not pursued. He sues, and the Ninth Circuit says, we're going to let the case go forward. We don't think there's a categorical rule that you can never pursue a retaliatory arrest case just because there's probable cause. I don't think these are the best possible facts. I think the Supreme Court will be often sides with law enforcement, will be wary of opening the door to what at least some members of the court might think of as frivolous litigation. And if I had to predict, they're going to align retaliatory arrest with retaliatory prosecution and say, so long as there's probable cause, you don't get to come to court.
All right. Thank you, Adam. Sarah has a criminal procedure constitutional issue.
I'm going to talk about a case called Gamble versus United States. Mr. Gamble was prosecuted by a state for being a felon in possession of a firearm and was prosecuted then by the federal government for being a felon in possession of the firearm for the exact same incident. So this is a case about the double jeopardy clause. The double jeopardy clause says that no one shall be twice put in jeopardy for the same offense. So what that means is if the state of Maryland prosecutes you for a crime, and whether you're acquitted or convicted, it can't prosecute you for that crime again. It also means that the state of Maryland cannot prosecute you for violating two statutes, for committing two crimes in one in one episode if those crimes have completely overlapping elements. So you just get one bite at the apple. But there's a long-standing exception to the double jeopardy clause known as the dual sovereign exception. And that is sort of an exception that comes out of our federal structure of government. And it says that you can be prosecuted for the exact same crime arising out of the same set of events, set of facts, if you're prosecuted by two different sovereigns. So here, the state prosecuted Mr. Gamble for being a felon in possession of a firearm, and then the federal government came in and did the same thing for the same incident. The dual sovereign exception has been affirmed by the Supreme Court for like 150 years. It's just like, it's part of the system. It's just the way it goes. But here we have a defendant that is arguing that the dual sovereign exception should be eliminated from our system, that those cases should be overruled. And what he argues is that it is inconsistent with the original meaning of the double jeopardy clause, that the framers intended to incorporate English common law on this topic, and that English common law, he says, was pretty clear that if you were acquitted of a crime in Portugal, England couldn't then prosecute you for the same crime. So if one sovereign had already taken a bite at the apple, that was the end of it. Another sovereign couldn't come in and prosecute you for the same crime. He also argues that there are early American cases that sort of affirm that principle, and that the dual sovereign exception was just like a wrong turn and we should get back on the correct road. The DOJ hasn't yet filed its brief on the merits in the case, but in their brief in opposition, they basically were like, these arguments have been considered and rejected a million times by the court, nothing to see here, move along, this is old news. And yet the court granted cert. So I think really, like, one really interesting question in this case is, how do we get here? This is not an open question as far as Supreme Court precedent goes. There's obviously no circuit split because it's a settled question. And yet here we are. And so I think part of the answer to that question can be found in a case a couple years ago, which asked the court to decide whether Puerto Rico counts as a separate sovereign from the United States for purposes of the dual sovereign exception. And the court, in an opinion authored by Justice Kagan, decided that it does not, that you can't have a prosecution by Puerto Rico and then a prosecution by the federal government or the other way around. And Justice Ginsburg filed a concurring opinion in that case, which was joined by Justice Thomas, in which she said, maybe we should just think about this thing again. Like, I'm not sure, maybe we should reconsider the dual sovereign exception. And so predictably, a flood of cert petitions followed, asking the court to do exactly that. So one interesting thing about this particular case is that the court relisted it 10 times. And what that means is that when the cert papers are done, when you have the cert petition and the brief in opposition and usually a reply brief, the case is scheduled for a Supreme Court conference. The court gets together, they talk about, should we grant, should we deny? If they deny, then the next order list says cert denied for the case. If they're thinking about granting, in the last few years at least, what they usually do is they will relist the case, which means they schedule it for the next conference to talk about again. And for most cases that they grant, there's one relist and then they grant. This case got relisted, and I'm sure the defendant was like, yes, relist. Got relisted again and again and again and again, 10 times, which is a lot. Doesn't set the record, but it's a lot. So usually what's happening, and we don't know what happened, but usually what's happening when there's that many relists is someone is writing a dissent from the denial of cert. One might think perhaps RBG was doing it since she had authored the concurring opinion saying we should have a do-over here. And if that's what happened, then she wrote a persuasive dissent from denial that convinced at least 3 of her colleagues, well, maybe we should grant. So we don't know what happened, but in the end, they have granted, and here we are. I think like the other case I talked about, Gundy, there is this dynamic at play here where there's this sense of that there's an over-criminalization in federal law, that to have this dual sovereign exception means something different than it used to because there are many more crimes that are both state and federal crimes. They're just because there are many more federal crimes, and there's a sense among, as I mentioned, among some justices that the federal government is aggressive. Some might think too aggressive in its prosecution of crimes. And so I think that's sort of at play here. There's a number of amicus briefs supporting the defendant in this case, including from Orrin Hatch, Senator Orrin Hatch, and making exactly that point. So I thought that was a pretty interesting thing. It's hard to predict what's going to happen. There's the fact of a grant, I think, suggests a lot of momentum for the defendant, but there are these other things at play here too. So that sort of maybe might give the government some hope. One is this principle of stare decisis, which basically says when the court's decided an issue, even though the court is not technically bound by anything, by its previous decisions, it can overrule them. There's this sense that it should stick with the rule it has unless there are exceptional circumstances. As the court in these last couple of years has shifted to the right a bit, the more liberal justices are very concerned about stare decisis. They don't want decisions and precedent that they like to get overturned. And so you saw this play out a little bit last term with a case about public unions, that there is some, they have the heebie-jeebies about overruling things because they don't want to erode this line of stare decisis. And so even though some of the more liberal justices might be inclined to think to be a little bit more pro-defendant than maybe some of the more conservative ones, they might have a pause about overruling these, this 150 years of cases. There are also practical things to think about. So if you get rid of this exception, then you have to think, well, so how does it work? Is it the first sovereign that has jeopardy attached that, seats a jury or whatever the thing is that will make jeopardy attach in a particular case? They get the only bite at the apple. Is there some supremacy clause principle where the federal government has to be given an opportunity to say, no, we want to prosecute, not you? Is it the opposite? Is it are these traditionally state things? Should the state have the chance to sort of have the right of first refusal? Those issues have never been worked out because there hasn't been a need for cooperation. But however you do it, there are going to be cases where there are policy choices of the non-prosecuting sovereign that are going to potentially be undermined because the other sovereign doesn't view this particular crime as worthy of as much punishment as the non-prosecutor does, or because the prosecuting sovereign, jeopardy attaches and then they screw up the trial and there's a mistrial and that's it. That's the end of it. No one gets to prosecute the person. And these sort of potential policy issues do play out in a real way in the real world. There are, particularly in cases like civil rights cases, police misconduct cases, those are kind of traditional areas where there's a state prosecution, at least historically this has been true, there are acquittals, and then the federal government comes in and gets a conviction because they're more aggressive. And so this is probably before all of your time, but the Rodney King incident, for example, there was police brutality, the police officers were acquitted in state court, bad things ensued, but then the federal government came in and prosecuted the officers and obtained acquittals. And there are lots of examples in the civil rights area of that happening. So I think that's going to be in people's minds. The other thing hanging over this case is the special counsel Robert Mueller's investigation. As we know, the president has the authority to pardon people for federal crimes. He does not have the authority to pardon people for state crimes. And so in news accounts and just chit chat about whether the president will pardon people, there has always been discussion about, well, he can pardon people for these crimes, but then a state with criminal jurisdiction could come in and prosecute them for state crimes. But if jeopardy has attached and then there's a pardon issued and you get rid of the dual sovereign exception, that's going to take away the ability of states to do that. So I think that's going to be on people's mind too. So I think this one's really hard to predict what's going to happen.
Thank you, Sarah. Angela, another death penalty case, this one from Missouri.
Yes, so the second death penalty case I'm going to talk about is Bucklew versus Presith. Mr. Bucklew was convicted of first-degree murder, rape, kidnapping, related crimes. He was sentenced to death. He's not challenging his death sentence. He is challenging the manner of execution in this case. He's arguing the Missouri executes by way of lethal injection. And so he is arguing that lethal injection would be unconstitutional, cruel, and unusual in his case. It's an as-applied challenge because the United States Supreme Court decided in Glossop versus Gross that lethal injection was not unconstitutional. But he's saying because of this very severe and unusual medical condition that he has, that lethal injection would be cruel and unusual in his case. He suffers, and I have to warn you, the description of his medical condition is really difficult to talk about and listen to, so I just want to warn you. He suffers from a really rare, progressive, incurable medical condition called cavernous hemangioma. It causes these inoperable blood-filled tumors that grow in his throat, on his face, his head, and neck. And the tumors are really sensitive and they're susceptible to rupture. Even just touching his airway can cause his airway and his uvula to leak blood. And even something as minor as him chewing on chips or even snoring in his sleep can cause the tissue of his airway and his uvula to tear and the tumors to bleed. He has a very enlarged uvula, and it obstructs his airway, and it causes the tumors to bleed, and it's very difficult for him to breathe because of this. And because of the enlarged uvula, the difficulty in breathing is even more so when he's lying supine. So because of that, when he's lying supine, basically his airway is obstructed and he could suffocate. So to prevent that, he has to consciously and consistently monitor and kind of mechanically adjust his breathing to shift his uvula so that he can breathe, to permit airflow. He has to sleep on his right side with pillows stacked up so that he's at a 45-degree angle at all times. And even then, when he wakes up in the morning, I'll spare you the details. I mean, it's blood everywhere. I mean, it's just a really awful, horrible condition. Now, in Missouri, technically a person can be executed by either lethal injection or the gas chamber, but they haven't executed anybody by the gas chamber since 1965. They don't have a functioning gas chamber. It's in their museum. So they've been using lethal injection since that time. He's saying that if they execute him by lethal injection, it would be excruciatingly painful. He would slowly suffocate because of the condition that I just described. The process of even finding a vein because of the blood condition would be excruciating for him. He's saying they've never executed anyone with this condition. And so he's proposing that he be executed by means of a lethal gas called nitrogen hypoxia. And he's saying that it should be administered by using a gas mask that would be attached. And this particular lethal gas, he's presented evidence to show that it will cause him to become unconscious within 20 seconds so that he wouldn't suffer all the pain that he would if it was lethal injection. Now, the Supreme Court has previously decided in a case called Bays versus Reese that if a prisoner is challenging the method of execution, they have to first show that there's an alternative method and that alternative method would cause less unnecessary pain than the method that's being proposed by the state. And he attempted to do that in previous hearings. The state is arguing that state's arguing that he hasn't proven that. They say that this gas that he's proposing that they use has never been used in any state to execute anyone, that no one has ever administered gas by means of the gas mask that he's proposing, that there are no protocols for this method that he's proposing. And they're also arguing that he has not proven that the method that he's proposing is less painful than lethal injection. They're saying that the drug that they use, pentobarbital, which is the drug that they use for lethal injection, would render him unconscious within 20 seconds as well, possibly less. And so they're saying that he hasn't met his burden. And so the Supreme Court has to decide, among other things, whether he's met his burden under Glossop of showing that first that there's an alternative and that alternative as compared to the method that the state is proposing would be less painful. It will be argued on November 6th, and I think Mr. Buckler has a difficult case. That's my prediction. So we'll see.
All right, thank you.
That he has a difficult case. I don't think he's going to win.
And the Supreme Court in recent years, or maybe for many years now, seems to have had a great fascination with arbitration. And this term is no different than recent ones, and Beth is going to talk about a few of those cases.
I'm going to try and do a lightning type around here to talk about 3 cases that are on the dock. And as Steve pointed out, that arbitration is an area where the court has really had quite a focus in the past decade or so. Arbitration is a means whereby cases can be kept out of court and sent to an arbitrator. parties agree at the beginning when they have a contract to say, if something goes wrong in this contract, we agree instead of going to court, we're going to go to arbitration. They generally agree in that contract what rules will govern that. And it would be a matter of state law, generally of contract law, when you apply it. There's a federal statute that's the Federal Arbitration Act, and basically, to oversimplify, it says that federal courts should really respect arbitration clauses and not take cases when the parties have agreed by contract to go to an arbitrator. The first area of tension that the Supreme Court gave to was in consumer contracts. As we all started getting our cell phones, there are these arbitration clauses in there. If something goes wrong, you have to go to arbitrate. You can't sue. And there were other kind of consumer contracts like that. Then the issue really started being, okay, if there's arbitration, can you have class arbitration? Because many of those cases had to do with lots of consumers who didn't have much at stake. And so in order to even have that case brought, you have to bring it as a class so that there's enough, at stake to have the lawsuit actually proceed. And so the question was, how does that apply in arbitration? And then just last term, they looked at arbitration in the context more of employment and held that arbitration actually overrides some federal labor statutes. We come to this term and they have 3 cases on the docket. I'm going to go through the first one, which I think is probably, I was going to say it's the simplest because it has to do with some direct precedent, but it does get a little complicated. The case is Lamps Plus versus Varela, and this was an employer-employee terms of employment. There's an arbitration provision in it, no doubt, but they're not arguing about terms of employment. There was a data breach and the employee's information went out. So a class brought an action against the employer in federal court to sue. And then the employer said, no, we have to go to arbitration. And the court said, well, we're going to go to arbitration, but it's going to be class arbitration, because when we look at this and we look at the backdrop of state contract law, we say this is class arbitration, and the Ninth Circuit affirmed. Well, there was a case in 2010 called the Stoltz-Nielsen case that basically said courts cannot infer class arbitration. It has to be explicit, more or less. And the petitioner argues here that under that case, you cannot infer that there is class arbitration here. So the lower courts were wrong. The employee class says, no, there are some distinct state law principles here. There's more distinct language. It's not as general contract language, arbitration language as petitioners suggest. But they also have a very interesting argument about jurisdiction and whether the court should have heard the case at all. They're arguing that the Court of Appeals had no appellate jurisdiction because the employer got what it asked for. It moved to compel arbitration, and indeed, there's an order to go arbitrate. It's just that caveat that it's class arbitration that the employer doesn't like. So for all of you civil procedure geeks out there, this appellate jurisdiction will be an interesting question. And I would say, if there's a 8-member court, for example, and there's 4-4 vote, it's the kind of thing they might decide to go off a narrow ground like that and just wait for the issue to come back later. That all depends upon whether there's a confirmation, when the confirmation of the 9th justice occurs or not. The next case is New Prime versus Oliveria. And this has to do with an exemption in the Federal Arbitration Act, the federal statute I mentioned before that says, you should respect all these arbitration provisions. There is an exception there for employment of interstate truck drivers and some others, but includes interstate truck drivers. So the question comes up is, what about independent contractors who are interstate truck drivers? Are they covered by this employee exemption, or independent contractors treated differently? Interesting question, but now there is a question even before that. Who decides the answer to that? Is it the federal court, or is it the arbitrator? They're arguing in the arbitration agreement, it says all questions of arbitrability, whether something should be arbitrated or not, should be decided by the arbitrator. And this is a purported class action, and it was filed in federal court. It's about the minimum wage laws. And the district court and the Court of Appeals both denied arbitration. They said, no, we, the court, gets to decide whether or not this federal statute that talks about an exemption for contracts of employment of this nature, whether that applies to independent contractors also. And the courts interpreted that and said, you know, at the time that this was initially enacted, it was understood to include independent contractors also. This is much more of a case to me about the power of federal courts, as is the next one I'm going to talk about. The last one, not in the same way. I mean, federal courts, I think, are going to be very uncomfortable in like clear federal statutory interpretation like this, where they think this is our bailiwick, we should resolve this so everyone is treated the same and there's a common understanding of this federal statute. We'll see what happens in that. The other one is Henry Schein versus Ultra, I forget the name of this case, Henry Schein versus Archer and White Sales. This also is a question of arbitrability, who gets to decide whether the particular claim or issue is covered by the arbitration provision. Again, the arbitration agreement says it's for the arbitrator to decide, but here the court said this is wholly groundless. We're not going to send it to the arbitrator because the arbitration agreement said it doesn't cover injunctions when the plaintiff is seeking an injunction that doesn't go to arbitration. And here, the case that was brought did seek an injunctive relief. So this was an antitrust case also, just to give you the idea of the range of cases that are now coming up in these arbitration scenarios. So the federal court, you can see they're thinking, listen, we have authority, and if they said they're not going to arbitrate injunctions, a request for injunctive relief, and it goes to the arbitrator, they're taking away our federal court power. So again, the district court and the Fifth Circuit both, refused to send it to arbitration. To pose the question as well, despite the fact that it says it goes to the arbitrator, the court gets to decide it, you think, well, the case is going to go the other way. On the other hand, when you see the federal court saying this is wholly groundless, and like on its face, it's wholly groundless, it's almost as if they're kind of preventing a sham to go to arbitration. So there are really, I think, strong arguments on both sides, and we'll see what the court does on that one too.
Thank you, everybody. We have about maybe 15 minutes left, and what I'd love to do is maybe very quickly tick off a couple of cases that we would say are in the pipeline, cases where the petition is pending at the court. Court hasn't yet agreed to hear the case, but as Adam suggested in his opening comments, some of the cases we might mention very briefly would make it a much more interesting and high-profile term than some of the things the court has already granted. I don't know if everybody wants to mention one, or if you want to, do you have a couple you want to mention that are in the pipeline?
Well, I would think maybe as soon as Thursday, the court might take an Establishment Clause case about whether an enormous war memorial in the form of a cross in suburban Maryland violates the Establishment Clause bar on government establishment of religion. I think that's a case the court could take even with 8 members. The question of partisan gerrymandering, which the court managed to duck in 2 different cases out of Wisconsin and Maryland, will probably return to the court on appeal, not on the court's discretionary cert docket, but on appeal in short order from North Carolina. So I think those are 2 cases to look for.
I would also mention the Docket case, the question about whether or not the current administration's attempt to rescind the Deferred Action for Childhood Arrivals program is constitutional or not. It's so complicated, and the arguments have been shifting. I'm actually recused from the case, even though my firm's handling it, because in the prior administration, I helped defend DACA, and it's so, the question now is, can they rescind it? Is the rescission based on the fact that, there was a strong challenge to it begin with or not? And so there's a lot of shifting sands. There was an earlier case that we litigated in the last administration and lost, defending a similar program called DAPA that had to do with parents of children in the DACA program and had brought in DACA, but that never went into effect because the Fifth Circuit enjoined it. And then, you're going to hear some echoes here, it went to the Supreme Court, and Justice Scalia passed away, and that Fifth Circuit was affirmed by a 4-4 equally divided court. Moreover, in a later interview, Justice Ginsburg had suggested perhaps she would have sided with the what would some of the conservative side of the court in suggesting that the state didn't have standing. So there are a lot of issues swirling around there. There were some procedural machinations about discovery and all that actually went to the Supreme Court last term, and the court didn't get into the merits and just sent it back and say, just decide the threshold ones. We're not going to get into this discovery stuff, and could you do it expeditiously? So I think we're going to be seeing that back up at the court. And, it'll be follow on the travel ban case that they decided last term. So I think they're primed and ready for the case.
Sure.
And lurking in those cases that Beth mentioned and other cases working their way through the pipeline is this issue of whether you can get a nationwide injunction, whether you can go to one district court and sue the federal government or other people, but it comes up most often with the federal government, and get a nationwide injunction that applies throughout the country. And that issue has been percolating for a long time and has sort of gotten to the court and not been answered, and it lurks in a lot of different kinds of cases. And it's an important question for the federal government. They obviously think the answer is no, but it's also sort of an interesting point in terms of how case law develops in the country and how cases get to the Supreme Court, because there's an argument that where there's a challenge to the constitutionality of a federal law or a federal policy, you should allow what Supreme Court watchers call percolation. You should allow different courts to consider the question, and that's how you get a circuit conflict, or that's how the issues get fleshed out. And so those issues get best sort of teed up for Supreme Court review. If you have a nationwide injunction, prohibiting the government from doing something in the first case, then it kind of stalls out the development of the issues, and it encourages forum shopping by the challengers. So I think we could see something like that in the next year or so.
I just that's a very interesting issue, because the government's interest is not always so obvious that they would be against nationwide injunctions sometimes, because their programmatic interests where the federal government would want that. And in the prior administration, there wasn't a definitive position taken on that. Immigration was an area, I think, where it's more difficult to argue against a nationwide injunction because of the nature of the agency's enforcement across the country, the fact that people, including who are in detention, are moved from one jurisdiction to another. But this administration just last week issued a memorandum instructing litigators for the government that the policy is against nationwide injunctions. We're involved in some other immigration where the federal government, DOJ, is trying to put immigration-based conditions on the receipt of federal funds, like ours is the case involving the Los Angeles Police Department. And there's all kinds of strategy going on about whether to seek nationwide injunctions as a relief, because that same type of case with that federal funding is in LA, San Francisco, Chicago. It's echoes of the Affordable Care Act also. Lots of complicated issues that government lawyers struggle with often to try and figure out how to handle that litigation. That's a really interesting issue.
And one we haven't mentioned is the question of whether Title VII's prohibition on sex discrimination in employment includes LGBT discrimination generally or transgender discrimination specifically. There are petitions involving both of those issues pending, and sort of a circuit split. If it's not an obvious circuit split, it's going to be one sooner or later if it isn't already. So that's another one that I think is in the pipeline. Let's spend maybe 3 minutes on Kavanaugh. Do we want to make predictions? Is Kavanaugh going to become a Supreme Court justice? Anybody? No, nobody wants to make predictions. Next subject.
My intuition changes with the day,
Yeah.
Probably yours too. And this is
Fluid.
I mean, we may have some expertise up here on some things, but this is an area which is really going to be governed in large part by public opinion and politics. So your gut is as good as mine. Let's have a show of hands. Do you think there's going to be a Justice Kavanaugh? Who's on the other side? Who do you think he either withdraws or gets voted down? Oh, so very substantial consensus that he makes it.
Most of you still think he's going to be on the court. Understood. All right.
One observation I would make is how that, whether you want it or not, I think it has a negative impact on kind of the institutional of the court. I think as much as Chief Justice Roberts, for example, might very much want Brett Kavanaugh on the court, the process by which this is occurring is not great for the institution, certainly.
I mean, I think when you see a federal judge, any candidate for Supreme Court giving interviews on Fox News, basically campaigning for the job, I mean, it's just surreal and, just really difficult to watch the whole process. And I think a lot of it depends on what happens today, tomorrow, the next day, because every day something else is coming out. So, I'm one who, I'm just not sure he's going to make it.
All right, why don't we take a couple of minutes of questions, and we would like it if you could use the microphone down front here if there are questions. Anybody?
Come on down.
Allie, come on down. Just make sure it's on.
Yeah. Do you think the Sorna case is going to bring in any ex post facto clause issues?
Probably not. There was a case called Carr, maybe, versus the United States that I think basically resolved this. The United States' view is it is not an ex post facto problem because it applies prospectively to people who travel in interstate or international commerce, or not commerce, but travel interstate or internationally after the enactment of the act. And people on the other side argue, well, you're attaching additional obligations and potential penalties to something that has already happened. But I believe the court in the Carr case said it's not an ex post facto problem. But there are retroactivity issues, and I think that definitely is at play in the Gundy case.
Other questions? All right, I'll ask one. Is there a way to figure out what the first abortion case is that comes up on cert? Anybody?
I would think the case the court has to take is one that sustains a significant restriction on abortion or puts Roe at risk, like a fetal heartbeat law. So if an appeals court were to sustain such a law, which is not terribly likely, but not out of the question, I think the court would have no choice but to take it, and that would really put John Roberts in a tough spot.
So the fetal heartbeat cases basically make the ones that the states are passing say no abortion once a fetal heartbeat can be heard, which is 4 weeks, 5 weeks. It's hard to still have a right to abortion if you're going to uphold one of those laws. So there would be a direct conflict, but we don't have one of those at the court yet.
Right. We have versions of what we thought the court had fairly definitively resolved in a case called Hellerstedt 2 terms ago, that you have to do a kind of cost-benefit analysis on restrictions on practical access to abortion. And the lower courts haven't been following that case particularly faithfully. But that's a way of chipping away at hollowing out Roe. It's not an attack on Roe frontally.
All right, other questions or last comments from the panel? Anything we haven't talked about? Yeah, please come up to the mic.
This is a good wrap-up one, I think. Are you optimistic about this term, if it is in either case, if it's 8 or 9?
Optimistic how?
Good optimistic? I don't know. What do you mean? Like, if you're thinking that there will be good rulings and it'll continue to be a good institution, if you're pessimistic, if you're not optimistic, would be good too.
Beyond Adam's job description, but maybe somebody else wants to answer that.
I'll take it. I think it's going to be like the term after Justice Scalia passed away. There was an unusual, and Adam probably has written about this, folks have written about how there was really, you could see a conscious effort between, I think it was the Chief, Justice Kagan, and Justice Kennedy to try and find narrower grounds on which to decide some of the cases and to let things settle. There was one patent case, for example, that posed a very interesting constitutional question. They denied cert on this issue 3 times. And then once they had a full court again, they granted cert. And the government had even waived response. So I think we hadn't realized at the time, they're waiting till they have a full complement of justices. And even if they have 9 right away, it's really difficult for a new justice. I clerked for Justice Blackmun, who came on the court as the 3rd nominee for that seat. This was way before your time. And so the court had been empty for, I think, 11 months. I mean, shorthanded for 11 months to 8 justices. So there's a lot of catch-up. Somebody like Judge Kavanaugh is very different because he clerked at the Supreme Court for Justice Kennedy, so he knows the ropes, and he could jump in very quickly, as did Justice Gorsuch, who also clerked for Justice Kennedy. But nonetheless, I just think that this term isn't going to be one of those ones. It's probably good it doesn't have a bunch of blockbusters, because I think they would prefer it that way to get back into a natural state of affairs.
One thing that's fun to watch, though, when there's a new justice, and eventually, whether it's Judge Kavanaugh or someone else, there will be one, is how oral argument dynamics change. And just, I know it's hard for the public to go watch arguments, but as people who participate in and watch them pretty often, it's, you get a new personality in there, and it's kind of fun to see how the new person is different or the same as other people, how the justices interact. They try not to really interact in an argument, but they don't have poker faces all the time, and so it'll be kind of fun to see whoever it is, to see what happens there.
One thing that's a likely positive in a small sense is that at oral arguments, you can almost always tell where the justices are coming from. Then people have this idea that they play devil's advocate. No, they actually ask questions that fully reflect how they intend to vote. But there was one exception. That was Justice Kennedy. That's a very important exception, because knowing how Justice Kennedy was going to go told you a lot about how the case was going to go. But once he drops out of the question, the Chief Justice moves into the median spot, and Judge Kavanaugh is also, a fairly straightforward questioner. We will have a much more transparent Supreme Court in the sense of knowing from the oral argument what the likely decision is.
Last questions, last comments. Elizabeth.
Not yet. I have some petitions pending, so.
Sorry, this isn't a wrap-up question. Can you clarify what the purpose of the dual sovereignty exception is?
Sure. So it sort of comes out of our federal system, the structure of the federal system, which has sort of respects the separate sovereign rights of states on the one hand and federal government on the other hand. And so I think the idea is it allows each different sovereign to exercise their sovereignty by declaring what is criminal.
The civil rights example Sarah gave is so good, too, because take yourself back to an area where maybe it was a little clearer. A state might want to prosecute someone who, a racist, someone who was violating somebody's criminal, like a law enforcement officer who was racially enforcing in a discriminatory way laws. They prosecute them, but the jury acquits. Nobody's going to, convict their local sheriff for doing what they thought was right anyway. Then the federal government comes in and says, no, you are violating federal civil rights laws, and we're convicting you, even though they're different laws. I mean, that was just, I thought, the great example that Sarah pointed out. And so that's got to be on minds.
Yeah, I think that, that it's an important role that the federal government plays. Before I was in the SG's office, I was in the Civil Rights Division for 9 years, and I did appellate work, but I worked on a number of criminal matters where there had been a state prosecution that was unsuccessful, and then the federal government came in and had a successful prosecution. And the police case is a good example. I had a cross-burning case. There was a different double jeopardy issue in that case, but it comes up in a way that's that liberals like more often than you might think. If you think of liberals as generally being pro-defendant, there are also these sort of policy objectives that are served by the dual sovereignty exception.
And similarly with the many killings of unarmed black men around the country where the police officer wasn't even prosecuted or maybe acquitted. The problem in that instance, of course, is that the federal civil rights laws are so difficult to bring a case there, which is why even under the Obama administration, they weren't able to bring cases in either Ferguson or Eric Garner case and many others. I mean, that's a difficulty with those.
Right. You can't have you can't have a federal law that just makes it illegal to kill somebody, right? You need a federal hook, and so there has to be sort of a race-based motivation or some kind of violation of civil rights. So it is harder to bring those cases. Yeah, so as long as the statute of limitations hasn't run, and it is, whether there was a state prosecution is officially part of the calculus about whether to bring those cases by the federal government. But sometimes with the police misconduct cases, and this is getting a little far afield from the double jeopardy, sometimes the state will just decide not to prosecute them because it's hard for them to prosecute one of their own people, and sometimes they even will come to the federal government and say, "Can you help us out here?" But sometimes they do prosecute unsuccessfully, or even successfully, but it's a small sentence or whatever. There's some other reason why the federal government wants to also.
I think the only one that was successful was actually the killing of Walter Scott in, was it North Charleston? This was the police officer who killed Walter Scott, shot him in his back as he was running away. The jury, despite seeing that video, came back as a hung jury, but the feds had already brought civil rights charges, and he ended up pleading. There wasn't a trial. He ended up pleading guilty to the civil rights, to the federal offense, in exchange for the state deciding not to rebring the state offense. But there wasn't even that was not a conviction for the murder, though. It was just pleading guilty to the civil rights.
But federal crimes often carry stricter, like longer prison sentences, and there's no parole, and so there are other reasons to.
Yeah, he got a lot of time.
Another good example, it just came to mind, was the church arsons. There are all these arsons of African-American churches in the South, and there was actually a task force in former administration to go after this. And it was a higher priority for the federal government that was looking at it as an interstate issue of race discrimination, which, maybe even thinking of the most favorable way of a local community, it might not be what they were focused on prosecuting.
All right, I think we'll make that the last word. Please join me in thanking the panel. And thank you again to the American Bar Association Division for Public Education and the Program on Law and Government. And stay tuned to an interesting Supreme Court term. Thank you.
That'd be great, thank you.